Hello, and welcome to Immigration Talk, a space where we hear from an expert on matters related to the immigration industry, law and policy, and practice. I'm Rosalie Van Staldeinen, and joining me is immigration lawyer Joel Sandaluk. Welcome, Joel.
Thanks for having me.
A pleasure. Joel, how do you draft a service and/or retainer agreement for an application with an undetermined processing time?
This is something that can be really challenging in immigration law because there's certain types of services that we provide that can last many years, and they can also be extremely difficult to determine not only how something will conclude, but when it'll conclude. And it's very important not only for us to explain that to the client at the outset of the relationship, when we talk to them about our expectations and what their expectations should be, but the other important thing that we do is limit our retainer agreements to a very specific service. And that's a service that we are aware of the appropriate time frame. So an example of this would be in an application for permanent residence on humanitarian and compassionate grounds. We will typically enter into a retainer agreement with a client that specifies the preparation and submission of the original application. And when that service is completed, the retainer will be fully billed out and our work on that matter will be done. And the client will understand that at the outset. The reason we do it in this way is because in some cases, it takes a significant amount of time for the government to actually make a determination on whether or not there are sufficient humanitarian and compassionate grounds to permit a person to remain in Canada. Sometimes these applications can be determined in 8, 9, 10 months. More likely, however, especially recently, they can be running 18, sometimes 24 months or longer before we reach a determination. And the important thing to bear in mind is that there can be other intervening events during those 18 to 24 months that are relevant to the application and that you may need to update. Now, that's why it's so important for our initial retainer at that point to be concluded, because if you are in contact with your client, as you should be, and they advise you of a significant event, for example, the birth of a child, the diagnosis with a serious illness, some significant event back in their country of nationality, you might want to provide additional evidence or additional arguments that address that and put it before the decision maker. But if you are still subject to an open-ended and very vague retainer agreement that you entered into a year and a half before or more, you're arguably on the hook to continue to provide updated information. And even if legally speaking, you're not exactly on the hook, you are certainly on the hook with that client. And what that does is it has the effect of essentially undermining your solicitor-client relationship with that person and poisoning it if you begin to resent them or they begin to resent you for constantly asking for more money for a service that should typically demand a further legal fee. So for that reason, we try to draft our retainer agreements in a very strict and restrictive way that focuses on individual services. For example, the preparation and submission of an application for permanent residence in Canada. What we also do, however, is we provide specific exclusions in that retainer agreement because there are certain events that we know are not a certainty, but are a likelihood. So for example, the necessity of providing updated information to reflect changes in personal or national events. Anything that we can foresee that might be relevant. In the context of a humanitarian application, stage 2 is relevant. And what happens is after we receive stage 1 approval, we will clearly indicate that there is a second stage. They may choose to retain us, they may choose not to retain us, but that's a conversation that we'll have going forward. So the important thing with the client is to make sure they are expecting to pay additional fees if additional services are required, but also to maintain an open line of communication with that client to make sure that they understand what is going on and what would be of some assistance with that application. The other reason that's helpful is because not every intervening event will necessarily require an additional fee to be paid. For example, something relatively minor like a change of employment or a change of address can be updated to immigration with a simple letter or an email, and a client will appreciate having that done and appreciate that they don't have to pay for it, despite the fact that they should have the expectation that additional fees will be necessary for additional services. So it's a good way of maintaining, a very positive relationship with your client at a very, very low cost. The other thing that we always try to bear in mind with these kinds of arrangements is that the clients themselves have to be clear on the timeframes involved. The fact that we don't necessarily know how or when a matter will be concluded. There's a lot of different types of files that this is relevant to. For example, I've mentioned humanitarian applications. Danger opinions are another classic case where they can stretch out for years. And even in the case of individual files that are relatively well-defined, what we typically will do is enter into multiple shorter-term retainer agreements when an additional service is necessary. And this is important for a couple of reasons. It's important because it allows you to negotiate a fee with a client being more fully familiar with their circumstances and with the facts of their case. But what it also does is it allows you and your client to continue to refresh your relationship and renegotiate whatever is necessary to renegotiate at any given time. And it's not necessarily just advantageous to the lawyer, it's also advantageous to the client to understand what precisely they're paying for and what precisely they are getting in return. And it's a little different, these types of retainer agreements, than a retainer agreement that is entered into for a service with a much more specifically defined lifespan. For example, an application on express entry or a study visa or something like that will typically be also very well defined, but rather than being fully billed out before the matter comes to its final conclusion, it will be fully billed out at the end, but with stages of billing essentially inserted into that retainer agreement. So at an event, for example, upon receipt of an ITA in the case of a permanent residence application, additional fees will be required and additional services will be provided and billed out. So in the case of something that's much more clearly defined, it's a lot easier to set up a retainer agreement in that way. And it's very important for you to be able to distinguish between those two types of services, because they're, at our firm, we do a lot of well-defined services and we do a lot of very poorly defined services in terms of time frame. And it's important for us to be able to explain this not only to ourselves when we draft these agreements, but also to our clients. Because in the case of a lot of clients, it doesn't sit well with them that they might pay a significant legal fee, not have a matter be concluded, and not necessarily have it be all that clear of what is coming down the line. So the better we're able to explain that to our clients and why, the better we're able to provide, a valuable and a meaningful service, and we're better able to have our fees reflect the value of the service that we're providing.
Well, thank you very much for walking us through this helpful strategy for drafting the service and/or retainer agreement under these particular conditions. Thank you.
Thank you.
Let's talk again.